We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that hearing, the parties addressed several related matters.
What if the clothes he wore could decide his fate? Today, the courtroom froze as the judge ruled on one of the most controversial motions in the Tyler James Robinson case, a man accused in a story that's already dividing millions online. Should a murder suspect be allowed to appear like an innocent man, in civilian clothes free of shackles, when the whole world is watching? The judge's decision shocked everyone in that courtroom, and what happened next could change how high-profile trials are seen forever. Stay till the end because this ruling may not be what you expect, and the reason behind it will leave you speechless. If you love uncovering the truth behind the headlines, hit subscribe and join us here on Unraveled Crime, where every verdict tells a deeper story. It began quietly, a routine filing in a Utah county court. 2 weeks before his scheduled hearing, Tyler Robinson's defense team submitted a motion. It wasn't about evidence, not about witnesses, not about guilt or innocence. It was about clothes. Robinson's attorneys asked the court to let their client appear in street clothes, a shirt, pants, maybe a jacket, instead of the bright jail-issued uniform he'd been wearing during his earlier appearances. They also asked for something else, that he be allowed to appear without shackles, no handcuffs, no ankle chains. To most people, it might seem like a small detail, but in law, perception is everything. When someone enters court in an orange jumpsuit, the mind fills in the blanks. The presumption of innocence, the foundation of American justice, starts to blur. Even before the evidence is heard, a silent verdict begins to form, and Tyler Robinson's attorneys knew that. They argued that their client had the same right as any defendant in America, to be seen as innocent until proven guilty. It wasn't about comfort. It was about the Constitution. The motion drew immediate attention because it touched a nerve that runs deep through the American legal system, the conflict between security and fairness. Every defendant has the right to a fair trial. Every courtroom has the duty to protect its officers, witnesses, and the public. Where those two meet, things get complicated. Robinson's defense cited the Bryan Kohberger case, another high-profile murder trial where the judge allowed the accused to wear street clothes. The logic was simple. You don't want jurors or the public to assume guilt based on appearance. But this case was different. Tyler Robinson wasn't facing a jury yet. The trial was still years away. This was a preliminary hearing, a procedural step, not a verdict. And that's where the state pushed back. Prosecutors argued that, unlike Kohberger, Robinson posed a security risk. They said there was a legitimate reason for him to remain in restraints and jail attire. Those details? Sealed from public view. But the implication was clear. The sheriff's office considered him a threat. The judge now faced a decision that went far beyond clothing, a decision that could echo across future trials in Utah and beyond.
And Chad Grunander on behalf of the state.
Your Honor, Kathy Nestor, Richard Novak, and Stacy Visser on behalf of Mr. Robinson.
Thank you. Welcome to both the prosecution and defense. Mr. Robinson, I understand, is appearing by WebEx. Mr. Robinson, can you hear us?
Yes, I can.
Thank you. Good afternoon to you all. We're here on the Tyler James Robinson motion to appear in civilian clothing and without physical restraints at all pretrial hearings. Because of some of the arguments involved in court security protocols, the court held a closed hearing on October 24th, 2025. During that hearing, the parties addressed several related matters. The first, Mr. Robinson's motion to strike the sheriff's response. The second, Mr. Robinson's motion to appear in civilian clothing and without physical restraints. The third, the sheriff's and Mr. Robinson's request to limit or exclude visual recording and photography in the courtroom. And finally, the fourth matter, the state's request to have all non-evidentiary hearings held remotely. The parties have stipulated that the state's request to hold non-evidentiary hearings virtually, as well as the parties' joint request to limit electronic media coverage, both require further briefing. Those issues are not yet ready for the court's decision. To facilitate that briefing, the court directs as follows. If the state wishes to have all non-evidentiary hearings conducted via WebEx, it must file a separate motion. The court will not rely on prior briefing. The standard timelines for response and reply apply, and the parties must file a request to submit and request a hearing, if desired. If the parties seek to limit or restrict electronic media coverage, they may file a joint motion. Again, the court will not rely on prior briefing. That motion must address the factors set forth in Rule 4-401.01 sub 2 of the Utah Rules of Judicial Administration. Standard response and reply times apply, and the parties must file a request to submit once the matter is ripe for decision. The court took under advisement two issues: the motion to strike and the motion to appear in civilian clothing and without restraints. The court now issues its ruling. In regards to the motion to strike the sheriff's response, the prosecution and the sheriff's department filed a joint opposition to the defendant's motion to appear in civilian clothing and without restraints. Mr. Robinson moved to strike the sheriff's portion of that filing, arguing it was procedurally improper because the sheriff is not a party. At the hearing, all agreed that the sheriff's department is not a party in this case. The state and the sheriff's office nevertheless argued that the sheriff may file memoranda as a non-party. Mr. Robinson disagreed, but did not object to the court considering the sheriff's position on security. The court finds that the sheriff's department is not a party to this case, and therefore its joint filing with the prosecution was procedurally improper. Accordingly, defendant's motion to strike the sheriff's response is granted. However, under Rule 3-414 of the Utah Rules of Judicial Administration, the court is required to coordinate courtroom security with the sheriff's department. Consistent with that rule and with the defendant's agreement, the court has considered the substance of the state's opposition and the memorandum prepared by the court security director that was attached to it. Going forward, if either party has a security concern specific to this case, they may present evidence from the sheriff's department by affidavit, declaration, exhibit, or testimony. This order does not limit the sheriff's department's ability to coordinate with the court or otherwise act as authorized by law. Turning to the motion to appear in civilian clothing and without physical restraints. The parties agree that during trial, a defendant has a right to appear in civilian clothing and that any restraints must be concealed from the jury. Mr. Robinson now seeks to extend those rights to all pretrial proceedings. The court considered each request separately. In relation to request to appear in civilian clothing, Mr. Robinson asks to appear in civilian clothing at all pretrial hearings. He argues that the extensive media coverage of this case creates a real risk of prejudice if the public and potential jurors repeatedly see him in jail attire. The state, the sheriff's department, and the court security director opposed the request, arguing that jail clothing assists with safety and identification. The court has balanced these competing concerns. The case has attracted extraordinary public and media attention. Images of Mr. Robinson in jail clothing are likely to circulate widely and influence prospective jurors. Given the scale of that publicity, the risk of prejudice is significant. However, Mr. Robinson's, let me see here. As previously stated, Mr. Robinson sits before this court presumed innocent, and that presumption remains unless and until each element of every offense charged against him is proved beyond a reasonable doubt. To date, this has not occurred, and the presumption of innocence remains. Balancing these factors, the court finds that Mr. Robinson's right to the presumption of innocence outweighs the minimal inconvenience of permitting civilian attire, and Mr. Robinson shall be dressed as one who is presumed innocent. Accordingly, the defendant's request to appear in civilian clothing for all pretrial proceedings is granted. Defense counsel is directed to coordinate with the jail to ensure that this order is implemented, and the court further orders that if the clothing be provided 72 hours prior to any hearing. To the second request to appear without physical restraints, Mr. Robinson also requests to appear unrestrained during pretrial proceedings. He argues that visible restraints would prejudice potential jurors, undermine his dignity, and interfere with his ability to communicate with counsel. Rule 3-14 sub 9C of the Utah Rules of Judicial Administration requires that all in-custody defendants be restrained unless otherwise ordered by the court. The court recognizes that Mr. Robinson has no criminal history and no record of misconduct while in custody. However, the charges he faces are extraordinarily serious, carrying potential penalties of life imprisonment or death. The safety of Mr. Robinson, the attorneys, court staff, and the public must remain the court's highest priority. The emotional nature of these proceedings also raise the risk of disruption. Given these factors, the defendant's request to appear without restraint is denied. The court directs the Sheriff's Department to conduct an individualized assessment and use the least restrictive restraints necessary to maintain safety. If those restraints impede the defendant's ability to communicate with counsel or take notes, counsel may renew the motion. I wish now to also address the decorum and media restrictions. To mitigate any potential prejudice, the court will amend its standing decorum order. The media will be prohibited from photographing or visually recording Mr. Robinson's restraints and from photographing or recording him while entering, exiting, or standing in the courtroom. In making this amendment, the court has considered the factors in Rule 4-401.01 sub 2. This is a high-profile case with strong public interest. Restricting the recording of restraints strikes the proper balance between Mr. Robinson's right to a fair proceeding and the public's right to access and transparency. In conclusion, the court orders as follows. Defendant's motion to strike the sheriff's response is granted. Defendant's motion to appear in civilian clothing is granted. Defendant's motion to appear without restraints is denied. The standing decorum order will be amended to prohibit any visual recording or photography of the defendant's restraints or of the defendant entering or exiting the courtroom. This constitutes the order of the court, and a written order and ruling will be published shortly. Both defense and prosecution have stipulated to vacate the October 30th hearing. Additional time is needed to complete discovery and to file motions addressing whether non-evidentiary hearings should be conducted virtually, whether to impose any blanket restrictions on cameras in the courtroom, and any other motions that may arise. This matter is set to return before the court on January 16th, 2026 at 1 p.m. and again on January 30th, 2026 at 1 p.m. Both hearings will be heard and held in person with Mr. Robinson present to address these issues. And that concludes the order of this court. Counsel, thank you for being here. Mr. Robinson, we'll see you on January 16th and January 30th at 1 p.m. Court is now in recess.
When the defense motion was filed, the response didn't just come from the prosecutor's office. It came from the Utah County Sheriff's Office itself. They warned of public safety concerns, transporting an inmate across county lines, managing courtroom risk, protecting deputies, staff, and even the defendant himself. The Sheriff's Office insisted this wasn't about humiliation or optics, it was about safety. Robinson's attorneys fired back. They said, "The sheriff doesn't have a dog in this fight." Their argument was sharp. The issue wasn't about jail operations, it was a matter of constitutional law. A defendant's appearance, they said, should be decided by the court, not the county jail. But the sheriff's office wasn't backing down. They reminded everyone, once a person is in custody, their safety, and the safety of everyone around them, falls under the sheriff's responsibility. Judges can issue orders, but sheriffs enforce them. And when enforcement involves handcuffs, shackles, and security transport, the consequences can be life or death. By this point, the motion had become more than paperwork. It was a constitutional debate with national attention. Reporters noticed the unusual secrecy surrounding the case. Court documents sealed, private meetings, quiet conversations in hallways, and then confirmation. The judge announced that an in-camera hearing would be held. That means private. No media, no public. Inside, the discussion would likely center on security protocols, how Robinson would be moved from jail to courthouse, what routes would be taken, and what safety measures would be in place. It made sense. Revealing that information could put lives at risk. But it also fueled speculation. Why was the sheriff so concerned? Was Tyler Robinson a threat to others, or was someone else a threat to him? Tyler Robinson's name carries weight. He stands accused of shooting and killing Charlie Kirk, a prominent political activist and commentator. It's a case that's already polarized public opinion. Online, emotions run high. Some call him a murderer, others claim the evidence isn't clear. Many just want answers. But in the world of criminal law, those reactions have consequences. Sheriff's deputies worry about retaliation, about what could happen during a transport or in a crowded courtroom. One wrong move, one open door, one person trying to make a statement. In other counties, jails are directly connected to courthouses, short walks through secure hallways. But not here. In Utah County, Robinson has to be driven from Spanish Fork to Provo, a public route, in a marked sheriff's van. On a day everyone knows he's due in court. It's not paranoia, it's logistics, and every deputy assigned to his transport knows what's at stake. After reviewing the filings and responses, the judge made a preliminary ruling. Robinson would be allowed to appear at his next hearing, October 30th, in street clothes. It was a small but significant victory for the defense. However, the judge also made it clear this decision might not hold for future hearings. The debate would continue. And behind the scenes, new meetings were already being scheduled to determine whether this privilege could continue safely. For now, Robinson would stand before the court, not in chains, but in clothes meant to make him look, for the first time in months, like an ordinary man. But that image was deceptive, because beneath the shirt and slacks was the weight of a murder charge, and around him, silent deputies still watched every move. When word broke that Tyler Robinson would appear in street clothes, the reaction was instant. Social media lit up. Supporters of Charlie Kirk were outraged. Why give a killer special treatment? Some asked. He should be in shackles, others wrote. Meanwhile, legal experts saw something else. A test case for constitutional fairness. If a defendant can be judged by what they wear, then where does the presumption of innocence end? Some reminded the public that even the most hated defendants deserve due process. That's the law. That's the promise of justice. And yet the optics couldn't be ignored. A man accused of killing a public figure, walking freely, unshackled before the cameras. It struck a nerve, and it divided a nation already struggling to agree on what justice even means. When the day came, the courtroom filled quickly. Reporters lined the benches. Sheriff's deputies stood shoulder to shoulder along the walls. And then, silence. Tyler Robinson entered. No shackles, no orange jumpsuit. Just a plain shirt, dark pants, and the weight of every eye in the room. The air shifted. Some whispered. Others just stared. For a moment, he looked like any other young man facing a judge, and that was exactly the point his attorneys had fought for. But behind him, deputies stayed alert, hands near their belts, eyes sharp. The illusion of normalcy didn't change the reality of risk. The judge addressed the court briefly, reaffirming that future hearings would revisit the clothing issue. The matter, he said, was ongoing. Legal analysts across the country began to weigh in, because the implications went far beyond Utah. If the court ruled that jail clothing could prejudice perception, and if that ruling held up, it could reshape how defendants appear in pretrial hearings nationwide. Even the U.S. Supreme Court has wrestled with this balance for decades: security versus fairness. As one analyst said on national television, the minute you see someone in jail clothing, you think guilty. And that's the constitutional dilemma. Should the public's sense of safety outweigh a defendant's right to fairness? Or should justice risk a little more danger to protect the principle of innocence? For now, Tyler Robinson's case moves forward, slowly, cautiously, through hearings, motions, and sealed filings. His trial could still be years away, but the debate over his courtroom appearance has already set a precedent of its own. The question isn't just about what he wears, it's about what justice wears. When it looks in the mirror, is it blind, or is it influenced by color, fabric, and fear? Every lawyer, every deputy, every judge watching this case will remember this motion, because sometimes the smallest details, like a pair of shackles or a shirt, can reveal the deepest truths about who we are as a society. If you found this story compelling, don't forget to like this video, subscribe to Unraveled Crime, and turn on notifications so you never miss the next chapter in America's most haunting real-life cases. And tell us in the comments, do you think Tyler Robinson should be allowed to appear in street clothes, or should safety come first? Because sometimes what we wear in court can change what justice looks like forever.